So we are live now. Hello, very good evening, ma'am. Very good evening to one and all present here. A very good evening to everyone present here. So today, I, Vedant Sukrija, on behalf of entire team Just Caucus, welcome you all in today's webinar on the topic Power of NGT to take suo motu cognizance of environmental issues. So today we have Professor Nabeela Siddiqui ma'am with us. Good evening, ma'am.
Good evening, yes.
So before starting, I would like to give a brief introduction about the eminent guest speaker of our day. Nabeela Siddiqui ma'am is an assistant professor at Christ University, Delhi-NCR. Her research revolves around the broad themes of water conflicts and environmental constitutionalism. She was awarded a prestigious President of India, Dr. Shankar Dayal Sharma Gold Medal, the INS Prize, the Carmicheal Prize, and the Suresham Memorial Award for her masters. She has previously worked at National Law University, Jabalpur, and the NGT Principal Bench, New Delhi. Her interest includes constitutional law, environment law, and feminist jurisprudence, and she is an active member of the Global Network for Human Rights and the Environment and the International Society for Therapeutic Jurisprudence. So once again, I welcome you, ma'am, in today's session. Over to
Thank
you,
you
ma'am.
so much. Thank you so much, Vedant. And I'm really thankful for the forum for inviting me on such an interesting topic. I believe I'm audible. If this
Yes,
would
ma'am, you
help
are
out.
audible.
Perfect, perfect. So first of all, the topic is very interesting. And the reason it is interesting is I'll just tell you why it's very intriguing to speak on this topic. So I remember just 10 days back, I was representing India at the international conference that happened in University of Oslo. So we had, people from various jurisdictions. We had judges, we had ambassadors, we had a lot of people, stakeholders, or even, people who were working on regional corporations, or even, working in the UN directly. So a lot of them were talking about the idea of tribunalization and the emergence of e-codes, especially, environment codes also, and also the digital sites of code that we are having right now. Now, one thing that I on a very positive front that I saw was that India, along with a lot of countries, have taken the, let's say, lead in coming up with this explicit, or let's say a very specific statutory body to call it, as the National Green Tribunal. And we are amongst the few countries who have a specific, code devoted to only dealing with environmental issues, which is very, it's very welcoming. It's a very, progressive step that we've taken. So an appreciation on that part. But now the questions arise, what is the future that lies ahead? Or, what are the lacunas that are there, or what could we do to make the, tribunal more in functioning in a more better form? Now, that's one question that all of us were deliberating upon. And I'm really thankful to one of the professors from JNU, that is Dr. Nupur Chaudhary. She's also my mentor. So we had a very long discussion regarding and she's written a very decent paper on this. Along with Dr. Bharti from National Law University, Delhi. So when I discussed with these two professors, who also happen to be my mentors, they've talked about one important part. And I think suo motu cognizance is only one part of the issue that we are taking into consideration. But apart from suo motu cognizance, there are various other issues that, also deal with or are, very important with the NGT, which needs the legal scholarship to be looked into, which needs people to discuss about these issues. Now, first we look into the fact that why the establishment was NGT actually needed. So we'll just, quickly brush up through the history a bit. Now we've seen, we all know, and in fact, this year, 2022, we are celebrating 50 years of Stockholm Conference, if we all are aware. Now, this is a very momentous, time period for India and for a lot of other countries who've been participatory, or who've been signatories to the Stockholm Conference 1972, which has been the, the first international conference, basically, which has talked about, the environmental jurisprudence very specifically. Now, when we see it in that light, we see that, India has also done a lot of progressive works. And after 1972, because we were represented by our late Prime Minister, Mrs. Gandhi, who actually went there and, told about a lot of issues. And of course, she pointed out poverty as being one of the most important issues of Stockholm Conference, in Stockholm Conference of India. So when she highlighted, poverty is one major issue in India that is there. We also came to light about many other issues, that is the divide divide between global South and global North, and so on and so forth. But what happened after Stockholm Conference was quite beautiful. We saw an array of or flood of conventions coming up.
So yeah, there is some technical error on ma'am's part. So kindly give us 2 minutes. Ma'am will be there at any moment. Thank you so much. Please wait for a minute. Ma'am is joining. Thank you so much.
Am I audible? I'm extremely sorry. I think there was some issue with the internet. Am I audible, Vedant?
Yes, ma'am. Yes, ma'am. You're
Yeah.
audible.
So, yeah, we were talking about the evolution of environmental jurisprudence, right? So, when we see that after 1972, a lot of progress has taken place, and these were positive progresses throughout the world that we've seen. And one of the most important features that were present in the Indian Constitution were Article 323 and Article 253. Now, when I say that we already had one specific article which contributed to the or which helped in the formulation of the NGT, and I give credit to Article 253 is because Article 253 of the Indian Constitution is a very powerful tool. And when I'm saying it's a very powerful tool, it's because it says that, all the international agreements, conventions, etc., that you're entering into, or you're, signatory to. So you do a lot of, you can incorporate all these laws in the municipal sphere in India, and according to the suitability of the Indian texture, Indian laws, you can obviously pass their own laws while being a signatory to an international convention. So we had a beautiful article that was a part of the Indian Constitution from 1950 onwards. That's Article 253. We also included two more articles, that was 323A and 323B of the Indian Constitution. I think in 42nd Amendment, these two articles were added. Now, these two articles, what did this do was, they said that, they empowered the parliament to establish, both administrative, or, any kind of a tribunal, which would help in the justice. So this was the most important, two articles apart from 253, that is 323A and 323B, that is by virtue of 42nd Amendment, that talked about that, yes, in India also you can come up with the idea of establishing administrative units or tribunals for that matter. Now, these two articles were, they played a very important role, though, it does not infringe upon or touch upon the power of the Supreme Court under Article 136. But yes, it did, open the gates of tribunalization that took place in India. And very beautifully, what we see is that the NGT Act comes up. And of course, when a body is or an institution established by virtue of an act, we call it a statutory body, since of course NGT is not a constitutional body because it's not enumerated or mentioned in the Indian Constitution, but it is established by virtue of the National Green Tribunal Act, or NGT Act 2010. Now, we see the reason the NGT Act came up was we had major incidents in India and also globally also. So we had the Chernobyl incident at a global level, and a mini version of Chernobyl, or let's say an Indian version of Chernobyl that happened, was the Bhopal gas tragedy in India. Now, 90s was the era, 80s and 90s was also the era when we were, moving from being in seclusion to opening our gates to various kinds of, MNCs, etc. And they were coming up in India and taking up the role of, establishing their subsidiary, units or corporations in India. And one such was Union Carbide that came in Bhopal. Now, this tragedy, of course, it shook India to a larger extent. And we also see that, the case goes on and on. And we also have a legislation that specifically talks about rehabilitation of the Bhopal gas tragedy victims. Right. So these incidents triggered the idea, and also we saw that you had something called as the National Environmental Tribunal Act in 1995, but it did not couldn't do much in the larger sense. So later it was replaced by the National Environmental Appellate Tribunal Act of 1997. Finally, in 2010, that is almost after a decade, we realized that we need a more structural statutory body, and for that a more structural statute that must talk about the establishment of tribunal, that is the NGT Act 2010. Now, we also see that a lot of influence, or a lot of good influence, I would rather say, because see, in India, the best part about Indian judiciary and judicial activism is we give a lot of relevance to foreign judgments also. We give a lot of relevance to principles that are established in foreign courts also. So we are open to the idea of innovating, open to the idea of creativity, so on and so forth. So we saw that in New Zealand, in Australia, we had special green courts coming up, which are only talking about specialized matters related with environment. And in fact, if you just Google the name of Justice Preston, so Justice Preston has done a lot of good work in New Zealand, if I'm not wrong. So he's one of the most important judges who's talked about a lot of good environmental issues at that point in time. So what we see is that that a lot of good influence and good atmosphere for environmental jurisprudence was globally also coming up. So it was not only India's initiative alone, but also the international community as a community together was coming up and giving relevance to the much needed question of environmental issues and pollution and so on and so forth. So finally, after the Bhopal gas tragedy case, we finally come up in 2010 with this proper legislation which talks about the formulation of a green court or tribunal. And also we had a choice to either come up with a green court or a tribunal, and what we opted was for a tribunal because we inserted 323A and B, which talked about formation of tribunals. Now what happens is, one important observation that comes up is the principle 10 of Rio Declaration also, because it also talks about that yes, you need to have special green courts or tribunals for decision making. And in fact, if you note down your SDGs right now, that is Sustainable Development Goals. If you see, one of the goals is strong and peaceful institution must be established. So even today also we talk about the strengthening of institutions for dispensing of justice, etc. So even Principle 10 of the Rio Declaration also talked about that yes, we must come up with a specialized tribunal or court which would talk about the same. Now we also had another important push that we got in India was the Law Commission report. And the Law Commission report, especially if you talk about 186 report specifically, so you'll see that it talks about that yes, a green court or a court which specifically deals with environmental issues must be there. So all these issues, or all these, rather I would not say issues, all these incidents bit by bit helped in the backing up of NGT, or coming up of the NGT in the real sense or the real picture. Now very interestingly, what happens is when NGT comes into picture, it was given very good a good enumeration of powers were given, and a lot of mentioning of the fact that NGT will have the same role as of a civil court, and all these privileges etc were given to the NGT. But a structural layout was given to the NGT that it will have its own zonal benches, and zonal benches, of course we have the bench in Bhopal, we have a bench in Chennai, we have a bench in Kolkata, we have the bench in Pune. So these were the zonal benches that were established, and a principal bench at New Delhi of course would be established. So structure wise it was peculiar, it was different from the other tribunals, or rather let's say administrative courts, because this structure was for the first time laid out in a very different manner, especially for the NGT. And one another peculiar feature was the fact that NGT, it said, if you read the initial provisions of the NGT, especially section 2, where it talks about what matters will the NGT look into, because that's also a question: are all environmental matters be entertained by NGT, or any other matters would come up, so on and so forth. So it's especially it's very specifically mentioned that section 2 very specifically says substantial question of environment or substantial questions relating to environmental issues will be dealt by NGT. So that was made, very clear in the NGT Act 2010, that matters relating to environment will be, under the jurisdiction of NGT. But again, this whole line that is, matters relating to environment will be within the jurisdiction of NGT is again, it's susceptible due to the kind of interpretations that we have, because that's another point of inquiry. Now, another issue that was there, and I think that is from where our discussion starts, is that what acts will NGT rely upon while it's exercising its jurisdiction. Now, sadly, if you see one, I would rather say that this is one feature whereby the NGT's powers are very limited, is because we do not have, it cannot say, and it does not have a say in the Wildlife Act 1972. It doesn't have a say in the Forest Right Act very specifically. So this is one of the important issues that was there. Though we've given a long list of 8 acts, that are there that the NGT can enter into, but major chunk of 1 or 2 acts which still NGT cannot talk about is one being the Wildlife Act. So for example, you had the Water Act. NGT can legislate matters on Water Act. NGT can talk about it can legislate on matters relating to let's say EP Act, Environmental Protection Act, Biodiversity Act, so on and so forth. And the whole crux was substantial question relating to environment must be there. So this was very much this was the key feature of the NGT Act. But also one important question was, now you established the NGT by virtue of NGT Act, whatever it is, it's a statutory body, it's absolutely fine. Now the question, what kind of apart from jurisdiction, what role or what importance would it have in relation to the other courts? So for that purpose, they said that NGT will only deal with civil jurisdiction or civil matters, because it will not enter into criminal issues. That was one another way of saying. Also, if you see that the NGT Act, it would, bar the court from taking cognizance of any offense in the NGT, which means it will not, it will be silent upon, it will be not, talking about criminal issues, that is there. So that's one peculiar feature. And NGT will have the same powers of a civil court. That means, when in respect of trying a suit under the Act, it will have, all the powers, or it will act as a civil court as mentioned under the civil procedure 1908. So that's one important peculiar feature. Also, if you see, Indian Evidence Act in 1872 is exempted from the, in the relation of NGT establishment. So that was again very important feature that was there. Now, the question that comes up, or the questions that we talk about, is the fact that does NGT have a suo motu? Does it have a suo motu cognizance? Can it take suo motu cognizance? Now, suo motu cognizance means that, taking a matter on its own, or on its own choice. Now, what we've seen in the previous years, if you see, and especially when I was working as a part of NGT, we saw that NGT has played a lot of active role. And active role, let's say, Jacob Koshy's case that is there, or, the river pollution of Ganga's case. There were various, cases which, or news items even, which attracted the attention of NGT, and NGT has taken up these matters and, talked about various important issues that were there. Now, if you see, very importantly, you'll see that this question of suo motu cognizance comes up because a lot of allegation upon the NGT is there, that, the NGT Act nowhere, if you read the whole Act, 2010 Act, and from line 1 to line, the ending line of the Act, it nowhere mentions that the NGT has the suo motu cognizance power. That it's no provision talks about, explicitly mention that, the NGT can take suo motu cognizance of matters whatsoever. And it is completely silent. But even if being completely silent, NGT has, taken up matters on its own motion also. But now the question arises, does it bar the NGT from taking such matters? Now, if you see, very interestingly, and it's only now that, very recently in 2020, that I think it's a very recent judgment of this year alone, that if I'm talking about. So that judgment is called as the Municipal Corporation of Greater Mumbai versus Ankita Singh and others. That's a very interesting, very recent case, if I were to talk about. So there's a 3-judge bench in Supreme Court that sits, and it has a question before it. Now, the question is that whether the NGT has the power, that is to take suo motu cognizance of environmental issues. Now, if you see the Act, and if you do literal interpretation of the Act, literal interpretation means that you are reading whatever is given in its letter and spirit, and no innovation is being applied. Now, if you literally read the document of NGT Act 2010, it nowhere says that the NGT has the power to take suo motu cognizance. But here, in this judgment that I'm talking about, the very recent judgment, it said that NGT does have the power to take suo motu cognizance. And now, how do they, dwell on this matter is because they give a judgment and they say that, the NGT safeguards right to life under Article 21. And we all know Article 21 is a very important provision of the Indian Constitution, considering various other rights were also culled out from Article 21, personal liberty and life. So even in the absence of an application, or, whatever is there, there can be a self-ignited action towards prevention of harm. This is what the court says in its judgment, and therefore it clarified the stance of NGT, and it said that NGT had suo motu jurisdiction because to ensure natural justice and fair play, and this could only be given if there is an opportunity of hearing being given to the being given, and the NGT's order is effectuated. And very interestingly, if you see in this recent judgment that I'm talking about, though the judgment nowhere talks about the arguments that were advanced in the favor of the NGT, though they've highlighted in the part of the judgment what has been said against the granting of, or against the idea of suo motu cognizance in NGT. But the Supreme Court's overall judgment was by virtue of protection under Article 21. Though the Act explicitly doesn't talk about suo motu cognizance, yet NGT does have the suo motu cognizance, because only then it can ensure natural justice, etc., so on and so forth. So the court basically took a liberal interpretative, approach while coming to this conclusion. Because if you see the court's decision, it also says that the reason why NGT must exercise suo motu jurisdiction is also because you see the word in rule 24 of the NGT rules, that is NGT National Green Tribunal Practice and Procedure Rules of 2011. If you read it in light with the NGT Act, because we have an NGT Act 2010, we have the NGT Practice and Procedure Rules 2011. Now if you read both of these in conjunction with each other, and especially with rule 24 of the NGT Practice and Procedure Rules 2011, you'll see rule 24. What does that say? It says to secure ends of justice. Now, the question that Supreme Court highlighted in this particular stance was that how would you secure ends of justice? That would only be, be given to the NGT if the NGT, has the power, has a discretionary power, basically, to, secure justice, or to make sure that, natural justice and principles of natural justice are being, fulfilled. And that can only be if you read it in a larger sense. Then only you will understand that yes, suo motu cognizance also is enshrined in the whole idea of securing ends of justice as per rule 24. And this is what the Supreme Court held in this particular judgment. And it also says that if you use the term decision in addition to order, awards, whatever we call it, as per the section 20 of the NGT Act, you'll see that they apply all these basic principles like precautionary principle, polluter pays principle, sustainable development principles, intergenerational principles. All of these principles are effectuated or being applied for the purposes of, what are the purpose? The purpose is ultimately as per rule 24, that is meeting the ends of the justice. And hence, if you see, if you need to ensure procedural safeguards to the NGT, therefore, initiating suo motu action, whatever it is, the NGT can, definitely do it, but it can, it will be required to send a notice to the sender of a letter, who is probably sending the letter that this is the environmental issue that is there, and NGT decides to take up the matter. Then what the NGT needs to do is, it's required to send a notice to the sender of the letter or the author of the media report, whatever it is there, and then the action can be taken. Otherwise, this just merely suo motu cognizance being not present in the NGT Act 2010 would not debar the NGT from actually taking suo motu cognizance of issues. So this is one important judgment very recently which came up and talked about that, yes, if you liberally construe the idea of meeting the ends of justice, or the idea as per enshrined in Article 21 of the Constitution, you will come to a realization that yes, we need to ensure complete and full justice is served by the NGT. Now, another important issue, if you see very interestingly, is whether the powers and functions of the High Court infringe upon or intrude upon the powers and functions of the NGT, because this is another issue. Because if we see petitions in 226 or 32, 226 is High Court and 32 is Supreme Court. So if you read the NGT Act everywhere, it very specifically says that you always have the option of appealing against NGT orders or decisions, and definitely you can approach the Supreme Court. Now, the question that comes up here is, what about the clash between High Court and NGT in that case? How would you, handle issues here? Now, I'll apologize, it was just hiccups. Yes. So here, if you just see very interestingly, one important issue that this NGT also talks about is the exceptions to rule of alternative remedy. Because we also believe in the idea of, as per administrative and constitutional law, the rule of alternative remedy, and it has been discussed in a variety of cases, if you just see. Now, here one important feature is where you're providing an alternative remedy and it results in a breach of principles of natural justice or any procedure. If you are making a decision and it does not adopt alternative remedy, then of course there is a question that is worth looking into. Second thing is, if there is a petition being forced to adopt a statutory remedy that would amount to the case of a very apparent injustice, that's another case. Third is where a statute that provides for alternative remedy, if it itself is unconstitutional or there's a breach of the constitutional limitation, then again it attracts the whole debate of intrusion of powers. Now, if you see these above, if these principles, these three principles that I've talked about, these principles, and and the exceptions for the tribunals and the high courts, these are also applicable to NGT in the same fashion, because these principles are to be adopted by both tribunals and high courts, and similarly they also apply to NGT. So there are cases, which either specifically talk about NGT's jurisdiction or in relation to the high court, etc., or the special relevance of NGT, etc. But this doesn't mean that the NGT is a complete different unit altogether, and therefore it will not be governed by the idea of alternative remedies also. So this is not true. It's completely in the same fashion as it is for the other units whatsoever. Now, another important feature that we wish to talk about, that of course should be discussed here, is the fact that if you see the L. Chandra Kumar case. Now, L. Chandra Kumar case is a very important case of constitutional law, and we've discussed it in very different senses also. In fact, MV Naidu's case is also another case where we've discussed and again discussed both in the constitutional law, administrative law, and even in environmental law cases also. Now, this was a 7-judge bench in L. Chandra Kumar case, and what it did was it held that tribunals can only be supplementary to the high courts, right? And they are not substitutes to high court. Now, this is a very important observation, because L. Chandra Kumar case very specifically, whatever I just mentioned, it very specifically says that they're supplementary to high court. That is, they are in tune with the high court or co-equals of the high court, but they're not substitutes of the high court. Now, it observed, in this judgment, it was observed that the jurisdiction of the high court, especially under 226, and the Supreme Court, that is under Article 32, it is an inviolable basic structure of the Constitution. So if you see, this is a very strong judgment if you say it in a very broad and a very beautiful constitutional aspect. And also further what it said was that the courts and the tribunals, they can perform a supplemental role in discharging these powers whatever are there upon High Court and Supreme Court. But the word supplemental is very important if you see, and this is the judgment of L. Chandra Kumar versus Union of India 1997. That is much before when the NGT was even established. So it basically, it held that the decisions of the tribunals that were created under 323A and 323B of the Constitution, they will all be subject to scrutiny before the High Court within the jurisdiction, within whose jurisdiction the tribunal is basically falling. So this is a very important judgment, and therefore it is very important to examine the extent of judicial review powers that tribunals have, and how these powers will be overlapping with the High Court also. So this was very important judgment. Now here, this is a very interesting factor that comes into picture. That is the conjunctive role or the collaborative role that NGT plays with the High Court. It doesn't supersede the powers of the High Court per se, but acts in supplement. But that doesn't mean that there's also a rider here, but that doesn't mean that the environmental issues will be taken care of by the High Court. No, when you have a specific provision, that is the NGT Act 2010, which specially says that the qualification is substantial question of environment will be dealt by NGT. So therefore, all the questions that have the elements of environmental law will definitely be taken care of by the NGT. And this is relevant because in 2015, if you see, Supreme Court transferred approximately 300 cases to the NGT. And if you see, the writings of a famous writer that, has written, Nain Gill. So Nain Gill, he's written in Environmental Justice in India. That's the name of the book. So he very specifically mentioned that these 300 cases, the reason being, transferred to the NGT was that, there'll be speedy justice, or there will be swift justice, especially with respect to the jurisdiction of the tribunal, or the rule of alternative remedy, as has been developed, as I just talked about, right? So here the rule says, or rule basically talks about, that whenever there is an efficacious alternative remedy available under a statute, and here the statute would be the NGT Act 2010, then the High Courts will not interfere and admit the petitions unless a statutory alternative remedy has been exhausted, because even the High Court has the power of entertaining civil petitions or civil matters. So However, there is a rule of policy, convenience, and discretion that is there, and it's of course subject to exceptions that are there. And even in extraordinary case, if you see, the high courts may intervene irrespective of the existence of a tribunal or not. This is also another principle, and this happened in the case of Southwest Port Limited versus State of Goa in 2018. It's a very interesting case where you see the High Court entering or intruding in the powers of the already established statutory body. So here, this is another important issue 226 of the power of High Court vis-a-vis the power of the NGT. So this is one important issue apart from sumo motu cognizance. Another issue which is very important, which we've not taken up, but I will definitely take up in today's discussion, is the power of judicial review. So whether this the NGT has the power to judicial review. Now, of course, if you see or if you try to understand the word, what is judicial review? So judicial review basically is defined as the court's power to review the actions of other branches or other hierarchies of the governments that are there, especially the courts that we are talking about. And this is the power to invalidate the legislative and executive actions as being unconstitutional. So basically, it reviews the actions of the other branches of the or other levels of the governments that are there. So under this basic idea of judicial review, the Constitution of India, or especially the judiciary, is given the power of judicial review, especially to check the legality of the legislative and executive actions. And this is where the idea of transparency also comes up, or the idea of correction of power or balance of power also comes into picture. So these powers basically are derived from Article 32 and 226 of the Indian Constitution. And here, any citizen basically can move to the Supreme Court and High Court, especially to safeguard their fundamental rights. And they can also, talk about the idea of judicial review. So the power of judicial review has, if you see, especially from 1990s to 2000s and so on and so forth, you'll see it has been extensively used by the courts. And it has also been recognized as a very important or crucial principle of the Constitution. And it cannot be actually abrogated without affecting the basic structure of the Constitution. So this is the level that it has attained. Now, calling judicial review basically as the most important weapon in the hands of judiciary, if you see the judgment of SP Sampath Kumar versus Union of India and others, they have very specially mentioned in their judgment that the Parliament could basically set up an alternative institutional mechanism or arrangement for judicial review, provided if it is not less efficacious than the High Court. So that is the power of judicial review, and that is the importance they've given to judicial review. Now we come back to L. Chandra Kumar versus Union of India case that we discussed in context with the High Courts. Now in this judgment, another important facet that was discussed was that the court basically examined whether the tribunals are competent to test the constitutional validity of a statutory provision, rules, and whether the tribunals, have or they can be said to give effective substitutes for high courts in discharging the power of judicial review, because minded, the power of judicial review is given under the or is taken out or culled out from 226 and 32 of the Indian Constitution. Now basically what has been done is they've rejected the proposition that tribunals should be barred from adjudicating upon the constitutionality of legislations, and the Supreme Court has also held the position that it would defeat the purpose of the tribunal, because if you restrict the power of the tribunal to not undertake the task of judicial review, then basically you are undermining the basic reason why tribunals were being established in the first case. Now if you just study this, or basically you talk about this, you'll see that the jurisprudence that has been evolved by L. Chandra Kumar case, it's a very important case in itself. It has basically I would say it's one of the most fundamental cases of administrative admin law, constitutional law, and of course tribunalization. If you do not study this case without in exclusion with understanding the idea of tribunals and various other organs, it will be a very futile exercise. So it's a very recommended case that one should study. So if you see the jurisprudence that has evolved in the L. Chandra Kumar case, you'll see that, this had a very important impact even in the drafting of the NGT Act. Now, how did it impacted the NGT Act was because there was no provision which excluded the jurisdiction of the High Court, and it's nowhere mentioned in the NGT. And the Act is completely silent that whether what will be the nature, whether you can exercise judicial review or not. But if you see section 22 of the NGT Act, it of course provides that if there are matters you are not happy with, if you're not happy with the decisions, orders, or whatsoever, then of course the appeals from the NGT can definitely go to the Supreme Court. And if you see section 29, it also says that it excludes the jurisdiction of the civil courts on issues which basically could be adjudicated by the tribunals. So these two sections are there. However, the issue is still subsisting today, that whether this has generated a controversy between the High Court, Supreme Court, NGT, and their clashes with each other, and how one would look into. But we have a very interesting case, very recent one, if you see 2014, which has tried to solve this mystery that I'm talking about. That is the judgment of Madras High Court. Now, Madras High Court, in the case is called as Kolli da Maru. My pronunciation might be wrong. KOLLIDAMARU. That's the first bit of the case. So Kolli da Maru Patu Kappu, that is PATHUKAPPU, Nala Sangam versus Union of India. That's the name of the case that I'm trying to refer to. So this is a very important case. In this judgment of Madras High Court, what happened was it has relied on the judgment of IR Coelho versus State of Tamil Nadu, and also the judgment of L. Chandra Kumar case. And it said that the power of judicial review of the high courts, that is mentioned under 226 and 227, it is nothing but it is mentioned under the basic structure of the Constitution, and therefore any parliamentary statute, be it NGT Act, also cannot take away this power. So Madras High Court basically what it said was that section 29 of the NGT Act does not mention the jurisdiction of the constitutional courts, that is High Court, because High Court is a constitutional court, it's mentioned in the Constitution, right? So moreover, even if there's an express provision which excludes the jurisdiction of the High Court whatsoever, it will still be the High Court's power will not be undermined. So section 22 of the NGT Act basically just provides for a remedy, and it's not a right, since there is no specific mention of the idea of judicial review. That's one important aspect. Now, if you see another judgment, very interesting, that is Windsor Realty Private Limited versus Ministry of Environment and Forest, that is MOEF. This is a case of 2016. Now here, if you see the Bombay High Court, what it does was it again relies upon, or it retaliates the earlier judgment, that is the judgment of Sham Resorts and Hotels Private Limited versus Maria Rebelit. That's the case. So it relies on this particular case. It also relies upon L. Chandra Kumar's case. And again, it says that the legal question of whether, appeals that are challenging the NGT's order, whether they can be entertained by the High Court or not. That's also another question. So it relied upon L. Chandra Kumar's case, and it said, the writ petitions that challenge the order of the NGT may be maintainable before the division benches of the High Courts also. Now, this, refers back to the matters of the NGT. That is very important. That is the judicial contravention of the High Court into the NGT's powers or whatsoever it is there. But again, this is a judgment of the Bombay High Court that very specifically talked about that, yes, the divisions benches can handle matters relating to NGT. So this is another controversy which is very much being discussed about right now in the legal scholarship. Now, there is an exception to the NGT's power of, now, of course, since there is no provision of the NGT which explicitly talks about or hints towards the power of judicial review. So basically, the tribunal did not, found itself to exercise the power of judicial review, because since it's not mentioned, it, restrained itself. But judicial review cannot be basically exercised in respect to its own parent law, and cannot, result in the exclusion of the jurisdiction of Supreme Court and High Court. But as far as NGT is considered, since the act was silent, so since there was no hinting of judicial review in the whole act, the tribunal basically it entitled itself to exercise the power of judicial review, considering the benefit of doubt. But again, this was in conjunction with the jurisdictions of Supreme Court and High Court, because it could not interfere in their working also at the same time. So if you see the exception to the NGT's power of judicial review, basically, as we just discussed in the Bombay High Court judgment, it has very beautifully talked about the fact, or it has very beautifully reiterated the fact that the High Court and Supreme Court do also have powers, and they can enter into the working of NGT's whatever jurisdiction it has. So if you see the powers of the NGT basically to take judicial review, so we'll see that it is interesting to note the judgment of the L. Chandra Kumar's case again. So though L. Chandra Kumar has basically allowed for a limited power to administrative tribunals to assess the constitutional validity of the statutes that are there, but it also rules the it also rules the fact that founding statute will not be disturbed. So it would seem basically very convenient that NGT can exercise judicial review in terms of assessing the constitutional validity of the statutory provisions other than the NGT Act 2010 itself. So this is as far as the whole understanding or the whole package of the NGT's clash with the powers of the High Court and Supreme Court are there. So I think that's it from my end, because these are the three issues that I wanted to discuss. That is the conflict between the power of the NGT and the High Court, power of judicial review, and suo motu cognizance. So I think I've tried to, through case law analysis, tried to highlight these three issues. Thank you.
Yes, ma'am, you have covered almost everything in this session. So, ma'am, also I have a few set of questions to ask from you, if you allow me.
Absolutely, please go ahead.
So, ma'am, my question is, ma'am, despite having so many benches of tribunal in the country, why only principal seat of Delhi holds a specific relevance?
Relevance in the sense, what specific relevance does it have?
Like, ma'am, when we talk about NGT, if a very common man talk about, so ma'am, he thinks of that principal bench of Delhi. Ma'am, like, people feel that, there's a question from that, people feel that only the principal bench of the NGT holds the relevance, not the other benches. So
okay,
is this true according to you?
In terms of, if you read the NGT Act, so to whoever who has asked this question, if we give a blind reading of the NGT Act, nowhere it has been mentioned that the principal bench has more power over the zonal benches. It doesn't mention in this sense, and this goes back to the whole idea of Montesquieu. So Montesquieu also believed in the idea of division of power. But do we treat the judiciary above other organs? We treat the legislative, the executive, and the judiciary as co-equals, right? That's our understanding as far as the idea of separation of power is there. But judiciary enjoys its own independence of judiciary, which is a basic structure of the Indian Constitution. So if you read the NGT Act similarly, as far as the idea of separation of power, to give explicit power to the zonal benches, in the sense that matters related to the zonal areas relating to environment is handled on a more swift basis. That is why we've divided zonal benches, and principal bench is placed in Delhi, and the reason we call it the principal bench, because the seat being in New Delhi. But does the zonal benches have less power than the principal bench, or does the principal bench overrides the whole power of zonal benches? I don't think the Act anywhere explicitly mentions that. So since the Act doesn't mention, so I think that's the answer.
Yes. So, ma'am, my next question is, ma'am, what future does NGT as a tribunal holds in coming time when relating to environmental issues of the country?
I didn't get you. Can you please come again, the question?
Like, ma'am, basically, what future does the NGT as a tribunal holds relating to the environmental issues in the country?
Future of, basically, you're talking about the future of NGT, right?
Yes, ma'am.
Mm-hmm. Okay, so see, if you it's a very interesting question. Yes, so it's interesting in the sense, especially there's another area, had there been more time, I would have discussed, apart from judicial reviews, suo motu cognizance, and the idea of High Court, Supreme Court in conjunction with the NGT is considered. There are two more important issues that we should talk about: is climate change litigation in NGT, That is one. Rehabilitation and resettlement and NGT. That's another question, especially when you see Bhopal gas tragedy that, have the Bhopal gas tragedy case. It is followed by another important case, and we still have that case continuing. That's the Bhopal Mahila Sangathan versus Union of India. That is the in relation to the rehabilitation and resettlement is considered. Now, NGT plays a very important role, and as far as the future is considered, if you see very interestingly, the environmental performance index in India, currently the India's position. So we've slipped by many places, and though people from India allege that it's not a properly founded statistics, but even if we were to rely on that statistics being released globally, we'll see that environmentally we've de-performed at a various places, especially biodiversity, etc. Now, NGT plays an important role, especially because it gives a thrust to the Ministry of Environment and Forest. Also, it gives a thrust to the CB or SPCB to function properly. Because if you see the NGT, it can adjudicate on very interesting questions and very important questions, especially if you see the Schedule 1 of the NGT Acts. It very specially says that it says, in fact, if I'm not wrong, the case is called as Gaurav Kumar Bansal versus Union of India and others. That the name of the case. So it very specially says that an action plan on climate change, especially questions related in Schedule 1 should be mentioned, that is of climate change, because we do not have a legally binding document in India, especially under the United Nations framework for Convention of Climate Change. So how do we go about? And as far as India is considered, we've always seen that judicial activism and the whole idea of environmental jurisprudence evolved because of the actions and judgments from a case-to-case basis in India, very specifically, be it the evolution of the principles of polluter pays, precautionary principles. So I think NGT plays a very important role, be it, even in the evolution of whole jurisprudence on climate change is considered. Because if you remember very recently, NLSIU Bangalore was the first institution which had a discussion on a draft bill of climate change. How would, a climate change bill look like? And they were debating on various issues. And very interestingly, I was also a participant of that conversation. Very interestingly, it was seen that it's a very big term or a very big issue that we're tackling, especially in light of COP27 just around the corner, because we'll be having in Egypt COP27. And if you see SDG goal also that I'm just talking about, SDG 2030 commitment of India. If we see one of the SDG goals says strong institutions, that I highlighted in the initial stages of the conversation also. So strong institution would mean a strong judicial institution also. And that would be because the NGT plays such an active role. So of course, these lacunas that I just discussed, have we just, if we just fill up these legal research gaps, I think NGT is a very good forum, a very strengthened forum which talks about the most important issues of the nation. So I think, yeah, it does plays a very special role, especially in the coming of climate change litigations that will come about. Because if you see recently, there is a flood of plastic waste litigation that is taking place, a flood of climate change litigation all over the globe that is happening. And I think India is not also far away from the trust that we would feel when we would discuss about case laws relating to climate change, especially when it is touched Asia. So if you just see the neighboring nation Pakistan, we recently had a very, very, very bad flood, and right now what Pakistan is alleging is that the whole globe must pay for the flood that has happened in Pakistan. Why? Because it is because of climate change that this particular flood has happened. So this is the allegation by Pakistan. And from the Asian concept and from Indian concept, NGT will play a very important role, because all the notorious activities of the West and the pollution by the West is borne by the developing nations like us. So we need to have a strengthened institution, strengthened environmental lawyers, and of course a strengthened backup of laws that is there. So yeah, that's my answer.
So my next question is some sort of like pro NGT, I would say. Like, ma'am, why only NGT as a tribunal has been able to establish itself as a tribunal of relevance and objectivity as compared to other tribunals?
Yeah, okay. See, when we were discussing the sumoto jurisdiction also, if you see interestingly, and this is, this answer will have two ways of, this question will have two two ways of answering. One would be from my personal experience, and the other would be what theory says. So when we were discussing about suo motu jurisdiction also, so we see that, the NGT Act is silent on suo motu jurisdiction, whatever it is. But then you have different aspects in the NGT Act, be it Section 14, Section 15, Section 16 of the NGT Act, which, talks about this. But suo motu initiatives have been, taken, they have now become an integral part of the environmental jurisprudence in India. So especially in the case of NGT, and even in Supreme Court also, when NGT was not there. So this is one important feature. Now, if you see NGT, this debate whether NGT has or does not have the suo motu jurisdiction over environmental matters is a very debated issue that is there. But what we've seen is that NGT has taken cognizance of reports, newspapers, it has initiated proceedings on its own, right? And I were to say, for example, when I was working in the NGT, we've taken cognizance. When we were working at the NGT, we saw under the chairmanship of Justice A.K. Goyal, very actively we've taken cognizance of a very important clipping, that is a newspaper clipping that was there, that talked about the garbage kingpin in the different regions of Mumbai, which usually people don't talk about. So that's what we've taken about, and especially the progress or the good reforms it's shown, especially in river pollution cases. So I think NGT has played a very active role, and it has emerged as one of the most important tribunals, other than in contrast with other tribunals, I would safely say. Reason being, because of course it's backed by a lot of zonal benches. And in the first question that you raised, that whether 5 zonal benches, are they equally powerful and their orders are applicable across India or not. So there a recent judgment of Madras High Court, basically it disapproved of the 2017 central notification. And it does not, it says that you cannot term the North Zone bench in Delhi as the principal bench. You should call it as the North Zone bench. So that's another, it is there. So NGT Delhi bench is not superior to zonal benches. That is what the the Madras High Court in one of the judgments of 2021 says. And the perfect harmony that the zonal benches have with the other benches, that's also another peculiar feature, I think, that is there. So these are the various important features of I'll say NGT, success stories of NGT, that is there. But now there are certain works which NGT must do to basically check that how to check the progress of NGT. One is to tackle the various vacancies that are usually there. Now, for example, if you read the NGT Act, it says it quantifies the number of judges, expert members that needs to be there in the tribunal. But usually we'll see the places are lying vacant. So the filling up of all these positions and places, I think that's one area of concern which definitely needs to be addressed by the rightful authorities. And another challenge, if I were to talk about, especially in terms of NGTs or obstacles, if I were to say, is apart from the lingering vacancies that are there, is the fact that you are you do not have a specific idea of development that is there. Now, for example, we have a very strengthened tribunal, that is NGT, but what about the dilution of the environmental laws? So we need to also check that there is no dilution of the environmental laws that are taking place. So that's also one question that we should talk about. Also, why not include Wildlife Protection Act and Scheduled Tribes and Other Traditional Forest Dwellers Act of 2006, because these two acts have been kept out of the NGT's jurisdiction. So if we included, I think it would also widen the jurisdiction of the NGT. So I think these are the few steps that we can take to improve the NGT, or probably, let's say, strengthen the NGT. So yes.
So ma'am, coming to my last question. So ma'am, it's basically, as you mentioned that NGT do not have any same criminal matters. How are those cases being dealt in which there is a crime related to environment as well as civil matters?
Okay, this is a very, very interesting question. Okay, very interesting. I'll tell you why. because it's not about India alone. We are discussing this issue of environmental crimes at a global level or at an international level. Now, there is a whole lot of international lawyers that are coming forward, and they are saying recognize environmental crime as the fifth crime, right? War crimes, if you've read about, or various conventions on genocide, etc., etc. If you read, you see that there's a whole conversation internationally going out that recognize environmental crimes as the fifth crime, and also term it as ecocide, right? So ecocide is what we are trying to talk about, that ecocide must be recognized as one of the fifth crimes of against humans that are there now, against nature, sorry, that is there. So the recognition of environmental crimes is a very important feature. And if you check the NCRB report of India, now for example, NCRB report, that is National Crime Records Bureau, if you check the report, you will see there is a section which talks about the environmental issues also, and especially a lot of issues regarding trafficking, illegal trafficking of animals, etc. Now again, that's a domain of the Wildlife Act 1972. Again, NGT cannot do anything in the Wildlife Act 1972 because it's out of the jurisdiction of NGT. Right now, if we bring criminal issues within the jurisdiction of NGT, I think yes, this will be a game changer in the whole idea of environmental jurisprudence. Reason being, because it will be more empowered to give punishment, imprisonments wherever it is required, the deterrent factor. Now, but the question now here arises is, in this case, then you will also have to include, Indian evidence would also be attracted by NGT. So the NGT must have the power to, basically entertain FIRs, charge sheets, basically, record evidences, or basically so on and so forth, whatever the procedure is there. So in this case, it's very peculiar, but yes, I think it will be a welcome step. And I think, again, this would start with the international thrust, whereby it would start with the international thrust whereby we recognize ecocide as one of the crimes. The moment I think ecocide would be recognized as one of the crimes, that would put an international pressure on all the states or nations to include criminal aspects of environmental issues in their jurisdiction. And I think then we can expect that we might see a legislation, not the empowering of NGT entertaining criminal issues also. And if I'm not wrong, Jojo Mehta is working very explicitly on ecocide issue. So if you see the works of Jojo Mehta, that is there, she's working very brilliantly on ecocide issue. And my friend who passed away almost a year before, Polly Higgins, a friend. Why? Because I'm saying this because we were in constant touch, and when we were talking about the idea of ecocide, so she also was pushing. She's in fact the whole reason why the whole momentum about ecocide internationally is taking place. So probably it could be the path-making event like Stockholm Conference, if we recognize ecocide, and then international pressures are there upon nations to take up the environmental criminality aspect also. So let's just hope for the best. I think that could be one important development. Yeah.
So yes, ma'am, that was all from my side. Thank you so much, everyone, for joining today's session. And thank you so much, ma'am, for giving your insightful information on this topic. Looking forward to have such more sessions with you on some different topics in future. Thank you, ma'am. Thank you, everyone.
Thank you so much thank you, Just Corpus, for the lovely forum that you put up, and everyone for hearing me out on a Sunday, because it's very difficult. So yeah, thank you so much.
Thank you, ma'am.